evidence available, he could not be convicted of the offenses charged. Obviously, the former Attorney General failed to act on these recommendations which were made to him by the Prosecution Division. If he disagreed with the recommendations, I am unable to say, but I agree with them. Based upon these recommendations, I dropped the charges against Johnson Pundit Esiama in both the Unibank and UT Bank cases. In coming to this decision, I am fortified by the rule contained in Rule 40, Sub-Rule 2, Clause A of the Legal Professional Conduct and Etiquette Rules 2020, that is LI 2423, which provides that in a criminal case, a prosecutor shall refrain from prosecuting a charge that the prosecutor knows is not supported by the facts. But note that I have not yet dropped the charges against the remaining accused persons because I am currently in discussions with the receivers in order to understand the financial implications of any decision I may take in the future. Ladies and gentlemen of the media, my third reason for dropping the charges was that in some of the cases, the evidence led so far showed that there was reasonable doubt as to the guilt of the accused persons. And as stated earlier, the ethics of the legal profession mandate that a prosecutor should not continue to pursue a case in the face of overwhelming doubt regarding the guilt of the accused. In other words, where a charge is not supported by the facts and evidence, a prosecutor is ethically enjoined to drop the charges. I'll give you an example. In the case of Republic versus Stephen Opuni and another, the entire case was built around the fact that an untested liquid fertilizer, Litovit, was purchased by Cocoa Board, and further that the fertilizer was not efficacious. In the event, according to the case of the state, all sums of money spent by Cocoa Board to purchase this fertilizer caused financial loss to the state. Rather strangely, not a single farmer was called by the prosecution to prove this fact. On the contrary, officials at Cocoa Board who were invited by the investigators gave statements to the effect that Litovit fertilizer was one of the most effective fertilizers purchased by Cocoa Board, and that the farmers preferred Litovit fertilizer to the granular fertilizer. More importantly, in the course of the investigations, Cocoa Board took statements from two farmers. Whilst one stated that he did not see any significant change on his farm, the second farmer stated that after using Litovit fertilizer, he saw a significant increase in yield, and that Litovit fertilizer is a very good report from Cocoa Board, which covered field visits by Cocoa Board officials. The report, which was tendered, was to the effect that Litovit fertilizer is a very good fertilizer and that farmers actually prefer it to other fertilizers, and was the fertilizer of choice in areas in which Litovit fertilizer was supplied. This is clear evidence that, contrary to the case of the prosecution, the use of Litovit fertilizer rather increased the yield. The farmers who used Litovit fertilizer, including the then national best farmer, in their evidence testified that Litovit fertilizer increased, the use of Litovit fertilizer increased their yield, and that it was a good fertilizer. During the course of their investigations, the investigators had two reports from Ghana Standards Authority on Litovit fertilizer. The first report, which was later confirmed to have been done, and listen to this carefully, members of the press, to have been done at the Cosmetics Department of GSA, the department which does not have the mandate to test Litovit fertilizer, okay, indicated that the sample of Litovit fertilizer submitted for testing did not have any fertilizer ingredient in it. This finding was challenged by the accused persons and the investigators, together with representatives of Cocoa Board and the suppliers of Litovit fertilizer, took a second sample from the warehouse of Cocoa Board. This sample, which was again tested by the same Ghana Standards Authority, but this time by the proper department with a mandate to test fertilizers concluded that the samples taken was fertilizer in the first place and that the fertilizer was efficacious. Furthermore, it is interesting to note that in this case, the complainant, that is Dr. Addo Ampoma, who was the third prosecuting witness, PW3, lied under oath to implicate the accused persons, for which reason a perjury application was filed by Dr. Stephen Opuni against him. The then trial judge, Justice Hoyenuga, for reasons which are totally unacceptable, did not hear the application, but rather stated that hearing the application will prejudice the hearing of the main case. He therefore adjourned the application until the conclusion of the case. This is most unacceptable because in a criminal trial, it is important to hold the scale of justice evenly, and any doubt raised must inure to the benefit of the accused persons. Ladies and gentlemen of the media, my fellow countrymen and women, the judiciary in our country is independent under the Constitution. In the context of criminal justice, judges demonstrate their independence by remaining neutral and impartial arbiters in disputes between the state and individual citizens. The scales of justice must be held in a delicate balance between the obligation of the state to prosecute crime and the right of the accused to a fair trial. Conduct by judges that undermines the fair trial rights of citizens should be concerning to a self-respecting prosecutor. Without meaning to impugn the integrity of any of the judges who were involved in the cases in respect of which I have either entered a nolle prosequi or withdrawn the charges, I am deeply concerned not only about the conduct of some of the judges, but also concerned about the fact that the executive branch took certain actions that could be reasonably interpreted as inducements to convict the accused persons. An ethical prosecutor must endeavor to protect the innocent and convict the guilty, and one cannot do so if the judiciary is not impartial. When Justice Hoyenuga single-handedly expunged otherwise exculpatory evidence from the record in the Opuni case, and then proceeded to rule that the accused had a case to answer in his ruling on submission of no case, he was far from portraying a vraisemblance of neutrality. Indeed, he directly undermined the fair trial rights of the accused persons. Again, when in accordance with law and practice, Justice Anoche Jima decided that he was going to hold a de novo trial, that is a new trial, in the same Opuni case after when Hoyenuga went on retirement, the retirement of Hoyenuga. He was instantly transferred to Kumasi, and the case was allocated to a new judge, who then proceeded to adopt the proceedings and continued the prosecution. Also, the decision by the executive branch of government to promote some judges who were sitting on some of the cases is very concerning. The perception, whether true or not, is that the promotion may be an inducement to convict the accused persons. Ladies and gentlemen of the media, fellow countrymen and women, in conclusion, I wish to make it abundantly clear that I did not take these decisions lightly. As I indicated above, I consulted widely and reviewed the files diligently before coming to a decision on each of the cases. You would note that in some cases, such as the Snake case and the banking cases, I withdrew the charges against some of the accused persons, while others are still under consideration. I am keenly aware of the need to balance the public interest, in this case, against the interests and rights of the accused persons. Also, as Attorney General, I take absolute responsibility for all the decisions so far taken. I am not under any instructions or pressure to discontinue any case or to bring charges against anyone. Those who are in a haste to tag His Excellency the President of the Republic as a clearing agent should hasten slowly, because he is not responsible for prosecutions and has not directed me to drop any case. Moreover, with the exception of one charge of bribery in the Opuni matter, in respect of which, listen, no evidence was laid, None of the persons affected by my decision so far has looted state resources. There is a gulf of difference between the offense of causing financial loss to the state or misapplication of state funds and the offenses of bribery, corruption, or that of using public office for private gain. In the latter offenses, the individual charge can be accurately labeled as looters. In the former, it will be thoroughly unfair and actually defamatory to label them, and I will now take questions if there are any. Thank you.
Okay. Thank you very much. My name is Alfred Okanse. I work with Media Journal, TV3, 3FM, Onia FM, Onia TV. First off, I want to find out if this, what we are seeing now with you have been subjected to, which you say is unfair. And then also, from the reasons that you gave, especially with reference to the Atoforsen and the banking sector cleanup case, you referenced the unprofessional conduct of the former Attorney General. Are you minded or going to consider taking any action whatsoever against him if that's the position that you take because of the description that you give to some of the decisions that he took? And maybe finally, you give very detailed reason for the decision to discontinue the case against Dr. Siaman. With the UMB, clearly as indicated, 300 measures to have UMB, that money, unlocked with CBG. But in the UT Bank case that he was involved in as well, what reasons did you have in discontinuing that charge against him? Thank you.
We'll take a few more. Please don't follow Alfred's example. Stick to one as much as possible. Yes.
Senior, my name is Hansen Ajuman. I work with CTFM Channel 1 TV. On the first reason, which has to do with the ethics, and because you were lawyer for some of the accused persons, even though you did not represent them in court. I want to find out, would that be the posture going forward for all cases that your firm may have represented that the Attorney General's office is prosecuting? And because as a lawyer, you would definitely have to have faith in the case that your juniors will take before you allow them to do so, or yourself will do so, meaning that those cases you're going to discontinue seeing. And then for the second and third reasons, for some of the cases, people think that there are genuine reasons why the state should go against some people. For instance, for the Saglemi housing case, apart from the fact that the fact as the Attorney General's department made known that the houses were less than the number that was initially contracted for, and more money has actually been expended than what was agreed, the house or the housing project itself has stalled, and Ghanaians will want somebody to take the fall for that. Should we take it that this is the end, or you're reviewing your books to see if you can get some better evidence and even people to prosecute? Thank you.
Take another one, then we'll take a response. No? Right. There's no hand raised.
Oh, okay. Yeah, thank you very much, Alfred, for that battery of questions. Yes, as I made clear in the statement that I read to you, I think that every Attorney General has a constitutional obligation to make clear his or her decisions when it comes to dropping charges, whether you are entering a nolle prosequi or you are actually withdrawing the charges. That is because I think that an Attorney General is not above the Constitution, and an Attorney General is subject to the requirements of Article 296. Now, for those of you who are interested, Article 296 is on the exercise of discretionary power. All right? And the power to prosecute is discretionary in nature. Okay? You have to make a decision to file the charges. You have to make a decision regarding the witnesses that you want to call. You have to make a decision, regarding whether or not to drop charges, as I've just done, and so on. So it's discretionary in nature, and is subject to the provisions of Article 296, which says that the exercise of discretionary power cannot be arbitrary. All right, and then the exerciser of the power must be fair and candid. Right now, I don't know how anybody can be candid without explaining themselves. Okay, so for me, I think that this is a practice that has to continue. I may not in future be calling a press conference of this nature, but at least I may issue a press release, basically outlining the reasons why I have taken, I've taken a decision in respect of a prosecution or the other. Then your second question relating to compensation, I have not cited any formal request for compensation. As Attorney General, I'm not going to encourage it, and that if any request for compensation come, take it from me, I will fight it. Okay, take it from me, I'm going to fight it. Okay, so I'm not serving a warning to them not to bring requests for compensation, but if they do, I will fight it. Okay. Now, your third question said something about unprofessional conduct. I think I've. Yes. The former Attorney General. I think I want to reserve my views on that one. Former Attorney General. I think I want to reserve my views on that one, and to say that when we come to the bridge, we will cross it. So I'm reserving my comments on that one. Now, if you notice from the internal memo that I was referring to, there were two segments. One, the 300 million was in relation to Unibank. The 150 was actually in relation to UT. All right, and the memo covered both. And that is how come that I was comfortable dropping the charges, in both, because I took the view, which was, shared by the professional prosecutors, that a charge of causing financial loss to the state will not be sustainable. The reason is simple. Will not be sustainable. The reason is simple. The charge of causing financial loss to the state from accounting. All right. Now, if you say that financial loss has been caused, it means that through either the intentional or reckless, that is irrecoverable. Now, I have always taken the view that where the so-called loss is recoverable, then it is notionally, and practically not a loss. So if the state can pursue and recover it, I'll be hesitant to take action against a person. But what has happened, look, let's go back to the history. The offense of causing financial loss to the state was first enacted under PNDC law 78, I think. And that provision said anyone who does an act with intent to sabotage the economy of Ghana, or I commits an offense. Okay, when we came into constitutional rule, because of the vague nature of the provision in PNDC Law 78, the lawmakers decided to redefine it, and that is how come that the offense of causing financial loss to the state, is on our statute books. All right. So for me, I think that unless we have a situation where the loss is, irrecoverable, right, then you should not charge a person for causing financial loss. That is why the professional opinion of the prosecution division, is telling, because basically what it said was that, okay, the amounts in question for which the current governor of the Bank of Ghana was charged, okay, have been recovered. So if you've recovered the amount, then no loss has been caused to the state. So he should be discharged. Okay? It's as simple as that. Why the former Attorney General decided to, proceed with the charges and to put the governor of the Bank of Ghana, Johnson Esiama, through the harrowing experience of attending court with potential consequences for his liberty, I am yet, to find out. Okay, but I do think that ultimately, I haven't seen his reasons. He might have, given some reasons to the prosecution division. I haven't seen them, but I think that my guess is as good as yours. It was probably animated more by politics than by law. Right?
Are you mandated to make that memo public for us all to see, just in the spirit of transparency as you're doing now?
Well, I will think about it, because let me tell you something. There are public officers still serving in my department, all right, who are, who authored this memo. I have to think carefully about the consequences for them, in making the memo, public, all right, before I can do so. I have to be very considerate in making that decision. So I'm not ruling it out, but I have to be very considerate in doing so. Yeah. Yes. Not GHOne. Is this City? Channel 1. Yes, you asked about whether this is going to be my posture in all other cases in which my firm, is involved. The answer is no. The answer is no. That is because in some of the criminal cases, and I don't think my firm has taken any cases that are as high profile as this, right? But if they are defending a murderer, I don't see why I should step in and say I'm entering a nolle prosequi. Okay? Now, I will be very concerned if the state interest, okay, the state interest in the matter, okay, the state interest in the matter, has consequences. One, for the finances of the state or property of the state. I'll be concerned if it has consequences for the constitutional democracy that we operate. All right. But of course, I will be very careful with my juniors in chambers, taking every case and trying to bring it, to my attention. So this won't be the posture, because I will be very ethical, and of course, if there are situations of conflict of interest, I will recuse myself from decision making that may result in accusations of conflict of interest. Sagleme housing, very complex. Your question is, I think it's a very good question, because come to think of it, okay, for 8 years, that housing estate was left to the vagaries of the weather. All right. Despite the fact that the Honorable Colin Zauda and his colleagues were being prosecuted for various, offenses relating to the use of the funds that, were voted for the housing estate. The estate was left to the vagaries of the weather. The houses deteriorated, all right. They were vandalized, and so on and so forth. Okay. I think that at some point in time, there has to be some accountability exacted, all right. But it was the manner in which this was done that gave me cause to say that I'm aborting prosecutions, all right. Because take the case of Collins Dowda. At the time that Collins Dowda left office, okay, the expenditure on Sagleme was at 94 million. But he was being accused of misapplying 200 million. Now, some of you are lawyers or law students, others are just journalists, but just apply common sense. Why should somebody be charged for misapplying 200 million US dollars when it is very clear that whilst he was in office, it was only 94 million that was spent? Okay, that is telling. Secondly, in 2017, the Honorable Atachian, as I've mentioned, did exactly the same thing that Collins Dowda did as minister. At the request of the consultants, he signed certificates totaling 5 million United States of American dollars. Right? He was not charged for misapplying state funds. He was never even mentioned. It was in the course of the proceedings that it came up, and the judge was even shocked and asked rhetorically, are you bringing 2017 matters, to this case? Okay, so my decision was based upon the charges as framed. Okay, but it doesn't mean that I have abandoned the quest for accountability in the Sagleme matter. So I may come back to it as far as the quest for accountability is concerned. Are there any other questions?
We'll just take two more and then we'll wrap up. Two more questions.
Thank you very much. My name is Mutala Inusa. I work with EIB Network, GHOne TV, and Star FM. With respect to the cases that you have filed nolle prosequi and those that you have filed withdrawals, for the people out there, for those who are following the case, those who are in court will really understand that the AG has a discretion, like you have mentioned, and the AG also make the point that going ahead with the cases, the point is that the state is going to waste resources and all of that. In the minds of the ordinary Ghanaians, once the AG do not have a case, and those cases were not initiated by your administration, would it not be expedient enough to allow the court processes to continue? At the end, the court will acquit and discharge them if there are no cases. Again, with respect to some of the things that you have spoken about, the Sagleme affordable housing case, one thing is curious. You've mentioned, Honorable Atachian, that he's done certain things by issuing payment of certain amount of that. So Honorable Collins Dowda cannot be held responsible for misapplying 200 million Ghana cedis. This is the case that you file a nolle prosequi, meaning that in future it could be revisited. Is it the point that you are looking at reviewing the cases again, and at some point in time we will see Atachian and possibly Collins Dowda back in court? And my last one, I want to find out what is latest with James Chachekwesi, because one of the cases that you mentioned in one of your earlier interviews, and of course the case regarding Oliver Barker Fomawo, the treason felony one, also pending at the court. And of course you didn't say anything about the Democracy Hub cases that you also filed a nolle prosequi in respect of.
Last question, please. I think that was the last question.
Okay, all right. Yeah, thank you very much, Mutala, for the questions. Now, I have given you reasons why any prosecutor who takes the ethics of his profession seriously, okay, should not continue to prosecute a matter when he has come to the conclusion that the facts and the evidence do not support it. Okay, I cited Rule 40, Sub-Rule 2, Clause A of the legal profession, professional etiquette and conduct rules. I am bound by those rules, despite the fact that I am the Attorney General of the Republic. I am first of all a lawyer before being the Attorney General. If I were not a lawyer, I would not be appointed Attorney General. So I'm bound by those rules. And so if I have assessed a matter and come to the conclusion that factually and in terms of the evidence, that matter, I should not continue to prosecute the matter, all right, I will be in violation of the rules of the profession if I continued, you know, I mean, in that direction. So that is my basic reason, all right. I cannot violate the rules just because I want the public to feel that, okay, they were tried and acquitted, okay. Then also, I have told you that when you have filed a nolle prosequi, the possibility is there that you can file fresh charges, all right. Yes, so this is not the end of the road. We will look carefully at the actions of each of the individuals that were involved in making decisions about, a Saglemi, all right, and then make sure that if we are going to exact accountability, we have a factual and evidentiary basis for exacting accountability. Now, come to think of it, when consultants have gone to the field and made an assessment, they've examined the built environment and issued a certificate saying that work has been done commensurate with the value of the certificate, with a memo to Mr. Minister. Now, tell me if it is your view that the minister must leave his desk, go to the field, go and make sure that what they have said is true, even where the minister is not an architect, he's not an expert, he's not a quantity surveyor. You expect that he should go to the field and go and make that determination before coming to say, please pay this certificate. I leave that to, you to think about. So when I am reviewing Saglemi, I will take account of all these factors before coming to a conclusion that someone has been engaged in wrongdoing. Okay? And it is going to be a painstaking exercise. I want to assure Ghanaians that I am not the type of Attorney General who will file a case and go back and look for evidence after I have filed. That has happened several times in this republic, and that was displayed very publicly when you heard the Japa Gate, matter. Okay, when the former Attorney General was basically coaching the witness and telling him what to say in court. That is where you file a case and then you go back, you take a step backward to go and look, for evidence. I will not do that. And that is why I want to assure those who are saying that has been a delay in prosecuting people. All right? We are going to be diligent in our investigations, and that may take time. Exacting accountability is not a political exercise. It's not just a political exercise. It also involves legal technical matters that must be carefully considered by a team of investigators, prosecutors, and finally the Attorney General. Regarding Democracy Hub, and the rest of them, I thought that your interest was in knowing why the public office holders were left off the hook. I have discontinued the charges. I've dropped the charges against the public office holders. As far as Democracy Hub is concerned, I took the view and I expressed it. I don't know whether Alfred remembers, but I expressed it on your network that the prosecution was totally unwarranted and that it had the potential I should now come, very much like the cases in which I have said, that because of my strong professional and ethical views about them, I did not see the reason why, just because I have changed position now, I'm the Attorney General, I should continue to prosecute anybody who was involved in those cases. In the case of Democracy Hub, I was not involved professionally, but I took the view that it was a violation of their right to freedom of expression. So those of you look at Article 33 of the Constitution is on the enforcement of fundamental human rights. The exceptions are very, very clear, and you must demonstrate one of those exceptions in order to say that a person cannot. That is 33 clause 5 of the Constitution. You must demonstrate with evidence that a person is not entitled to the exercise of his fundamental right, and I don't think that happened in the Democracy Hub cases. So I discontinued them, and rightly so. Yes. Which one? Oh, GHOne. Okay. So in the case of GHOne, as I noted, I did not take these decisions without consulting the defense lawyers in all the cases. I consulted the defense lawyers. All right. The reason for the consultation was so that I am not seen as acting in an arbitrary manner. Okay. So I decided to consult all the defense lawyers, and of course, the lawyer for GHOne is the venerable, senior, and respected Tachu Chikata.
To go and review more cases. Honorable, it's up to you.
Yeah, it's fine. It's fine. I'm fine.
So,
I'm fine.
2 more, and please bear with us. 2 more, okay? Alfred, and then you.
Yes. Good evening. I'm Kenneth. I work with GHOne News. My questions are, the first one is, there's been name calling that the ordinary Ghanaian is saying that President John Dramani Mahama has become a clearing agent. Mm-hmm. My question is, are these cases, is the president aware that you've dropped these cases? What is the president's opinion on these cases? And then the last one is, just today, the special prosecutor declared the former finance minister, Ken Ofori-Atta, wanted. I want to pick your thoughts on that. And then when are you also going to start with your own prosecution of cases? We know that the oral committee has finally submitted their report to you. Thank you.
Okay, thank you very much. And in the spirit of the discontinuation of the case, I want to find out if you're going to review the case of
the cases that he has dropped and the cases that are pending that he's still reviewing. And so it is the matter that a lot of the people have asked questions about. It is a cases that people have raised questions. First of all, he talked about the principle that he represents. Refer to the law that allows the Attorney General to file nolle prosequa, to file withdraw cases and all of that, and the implications of those withdrawal, especially so also because the matter in relation to a nolle prosequa where charges are dropped, but the Attorney General can go back again to revisit some of these cases, and of course those cases that have been withdrawn or by way of filing notices of withdrawal. And that's one he explained clearly that at the time that the cases were withdrawn, if the Attorney General if the state had closed its case at that particular point in time, it means that
His Excellency was directly involved in most of the time issuing statements, writing letters. I saw the love letter to Cecilia Dapa stating, he'll be declared innocent. All right. So that is how Ghanaians labeled him declaring agent. His Excellency John Dramani Mahama cannot be labeled a clearing agent, because as I've said in my statement, all right, he has not been involved in any decision. I have not briefed him on any of these decisions. All right, I will at the appropriate time maybe do a cabinet memo, all right, so that His Excellency and my cabinet colleagues will be formally informed of the decisions that I have taken. All right, until then, His Excellency remains innocent and stands far away from the decisions that I've taken. And I have told you that I am, taking absolute responsibility for all the decisions. Okay, as the Attorney General, it is my responsibility. If there's any fault in the decisions I've taken, I will take I am taking responsibility, today, and I'll take responsibility in the future. Regarding the OSP, recall that the OSP law seeks to make the OSP independent of the Attorney General. Now, even though I disagree entirely with it, not because I am now Attorney General and I want powers over the OSP, but if you go back to the Parliamentary Hansard, when the law was being enacted, I was one of those who argued strongly that that power rightly belongs to the Attorney General under the Constitution. When I was making those arguments, the Honorable Gloria Ekufu was the Attorney General. All right, I wasn't the Attorney General, and I had not dreamt of becoming Attorney General. So I wasn't trying to arrogate to myself any powers then. Okay. However, because the legislative intent is to make the OSP independent of the Attorney General, I am a bit reluctant to interfere in the work of the OSP. However, I think that it is only right that because he's exercising prosecutorial authority, which belongs to me under Article 88(3) of the Constitution, all right, I should be in the know regarding, his actions. So he is one of the agents, OSP is one of the agencies under the Attorney General's Department, and at the appropriate time, I will call for a briefing on everything that he has done, including the press conference that he held, today. I myself, woke up to the press conference. I did not know that he had taken those actions. I'm not blaming him for taking the actions. Until I know the substantive content of the actions he's taken, I cannot, begin to say anything about them. There was a third one, Ken, if you remind me. Yeah, when am I going to start prosecutions? As I said earlier, mounting a prosecution is a very, very, very painstaking adventure. Okay, so we are going to look at the oral report. In fact, we have started reviewing them. My able Deputy Attorney General designate, the Honorable Justice Rimsai, has been tasked with reviewing the reports. We'll be having our first meeting, technical meeting, on Friday. And if there are any low-hanging fruits, I am sure you'll see prosecutions taking place, before the end of the month, or even into the early parts of next month. All right. But as I said, my position is that I will not charge anybody and go back and look for evidence, okay, against them. I will never do that. Look, maybe I should tell you this. In July of 2017, I was in my house when my son came and knocked on my door and told me that he had seen on the CCTV gun-wielding policemen at the gate. This was around 6:30. So I woke up, freshened up, looked into my own, the CCTV, And I saw them. I recognized one of them because as Deputy Attorney General, I used to work with them. So I recognized them. Because I recognized him, said, no problem. They are not armed robbers. So let them in. They came in and then said they were investigating me for corruption. In the Amihere, in respect of the Amihere plant. Okay? So I asked them, okay, what did they want? If they were going to put me under arrest, I was ready to be arrested. If they wanted to search my house, I just wanted a search warrant. Now they refused to give me the search warrant, and I refused to allow them to search the house. Eventually, when they showed me the search warrant, it detailed only 3 items. Okay? Documents, computers, and phones. So I told them, okay, so you have an arrest warrant that limits you to taking these items. So please go ahead and take them. They went ahead and took them. As for the documents, I told them they can go back to the AG's department because I didn't steal any documents on that transaction and take them home. So they left. After a while, they looked through the entire house and they left. They actually placed me formally under arrest, but then one of them, the inspector, said there was no need to take me in handcuffs to the police station. Now, after everything, they combed my laptops and phones and everything. They did their investigation. They found nothing. Absolutely nothing. Okay? And then they returned the laptop to me. Why am I telling you this story? I'm telling you this story because it was one of the most harrowing experiences that I've had in my public life. Very harrowing. The fact that you wake up in the morning and there are policemen, you know, in your house, searching the house, and then potentially they could take me into. I've never slept in a police house. I mean, a police station. I've never done that. I have defended criminals and gone to see what they go through. I don't want to put anybody's father or mother through that unless there is a reasonable basis to do so. So we are going to be very, 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 very careful, and we are going to be very diligent in investigating so that when we come to arrest you, we know that we are doing so because, all right, there's a reasonable basis for it. So to your question, when we'll start prosecutions, I can tell you we are working on the oral, reports, and if there's a basis, if our investigation shows that there is a basis, we will go ahead and then prosecute. Now, Alfred, I'm hoping that these 2 questions are your last questions because they will add up to 6 questions at this session for you. So, Gregory Afoko, the memo on Afoko, I'm really very keen about Gregory Afoko's case. So, the memo from the Chief State Attorney who is prosecuting the matter came to me 2 days ago. Okay? As I said, I don't want any of my decisions to be arbitrary without any reasonable basis. So if in terms of due process, internally, I ask those who are handling the matters, you know, to write memos to me, briefing me generally. If I review the memo and I have questions to ask, I either call them to my office or I mean it and say, can you explain A, B, and C, D in a supplementary memo to me? Okay? Then when they do that, and I'm convinced, I will take a decision one way or the other. So I have a memo on Gregory Afoko. Okay? I know he has suffered enough. He has suffered a lot. All right? I will take a decision on him, but I'll do so on the basis, of reasoned, on the basis of the fact that I have reasons for it. Now, the 2020 killings, as you have said, the IGP is investigating. I'm sure a docket will be built, and when that docket is built and brought to my office, we will take the necessary action to be able to bring justice to the families of those who were killed in the election. So I want to thank all of you for coming. Thank you for your brilliant questions. I'm sure the citizens will now be asking you more questions, when you go out there to report what you have witnessed today. So have a good evening and God bless you all.
This person is wanted by the OSP to answer charges in respect of several cases, including the following: contractual arrangements between Strategic Mobilization Ghana Limited and the Ghana Revenue Authority for the stated objective of the enhancement of revenue assurance in the downstream petroleum sector, upstream petroleum production, and minerals and metals resources value chain. Termination of a distribution, loss reduction, and associated network improvement project contract between the Electricity Company of Ghana Limited and Beijing GHOne Technology BXC. 3. Procurement of contractors and materials and activities and payments in respect of the National Cathedral project. Activities and payments in respect of a contract awarded by the Ministry of Health, initially commenced by the Ministry for Special Development Initiatives to Service Ghana Auto Group Limited for purchases and after-sales service and maintenance of 307 Mercedes-Benz Sprinter 305 CDI ambulances for the National Ambulance Service. Payments out of and utilization of the tax refund account of Ghana Revenue Authority. The fugitive's name is Kenneth Nanaya Oforiatta. The OSP declares Kenneth Nanaya Oforiatta a wanted person. He is a fugitive.
You're welcome back to the show. This is GH Today. I am Serwaa Amihere. I have to apologize to all of you, our viewers, for the delay. We had a challenge that was beyond us, but thankfully we're here. This morning on Hat Talk, I'm having a conversation with the first ever Minister for Youth Development. He's also the national organizer for the youth organizer for the NDC, George Opare Addo. He's popularly known as Pablo. Good morning, Pablo.
Morning,
you're welcome
Sarah.
to the show. Which one do you like, Pablo or George Opare Addo?
Any of
Either
them
way.
works. Yeah.
Right?
Any of them works.
You're welcome to the show. You haven't been here in how many years?
Very cool. It's been a long time. We're busily running around the country trying to rescue Ghanaians from the mess of the NPP.
Right, you're still welcome all the same. We're live on GHOne TV, we're streaming on Facebook, we're streaming on X, and we're streaming on YouTube. Please join us. If you have any questions for the Honorable Minister, we're happy to take them for him. Now, it's been about 3 weeks since you were sworn in.
2 weeks.
2 weeks.
If I'm not mistaken.
About 2 weeks.
Yeah, about 2
as the first ever
Minister
for Youth Development
and Empowerment.
and Empowerment. How is it like?
I've been called upon to serve by His Excellency the President. My job is to carry out how do we empower Ghanaian youth, how do we also create opportunities for them, and most importantly, how do we bring them to the decision-making table. So I have a job to do, and currently we are setting up the ministry. You know, it's a new ministry, so we needed to find a building. Currently we are operating, or the building that was allocated to us was the old sanitation ministry, so that is where we are operating from. As at yesterday, about 82 staffs have been posted to the ministry, and so we are still in the process of setting up. But that notwithstanding, we are working. We've started some preliminary works in putting together a technical team that is going to pursue the agenda of His Excellency President Mahama.
Okay, we'll talk about the setting up and the team and everything, because I am eager to know the kind of people that will be working at your ministry. But when you say that you're a Minister for Youth Development and Empowerment, what exactly is your job?
My job is very simple: youth development and empowerment. You see, so over the years, we've had a ministry that seeks to pretend to be doing stuff for young people.
Okay.
So we had a Ministry of Youth and Sports. Issues that affect young people are cross-cutting. You find them everywhere. And so you have every sector doing something for young people. But a lot of the time, nothing gets done because of the duplication of efforts. So you get Ministry of, let's say, Employment doing something for young people. You find Ministry of Trade doing the same thing. So there's a lot of duplication. The Sports Ministry too was such that sports itself is cumbersome. And sports has been reduced in Ghana to only soccer. And soccer, just the Black Stars. And so when you become Minister for Youth and Sports and you get to the ministry, because of the cumbersome nature and how difficult the sports area is, and because of the numerous issues that affect young people, cross-cutting across all ministries, it becomes difficult focusing on issues that affect young people. And so before you know, your focus is on soccer. I liken it to this situation. 22 players play football, and there is one leather ball that they all run after. When the Minister for Youth and Sports takes office, most often his focus is not on the 22 players, but that should have been the main focus. Rather, the focus is narrowed down onto the leather ball, and so all the focus goes onto the ball, to the detriment of the 22 men or women that are playing the game and they make the game very beautiful. And so if we focus more on the players, we'll score more goals and we will enjoy the game better. That is what President Mahama has done. Okay, focus on the ball at the sports ministry, and then let me get a separate ministry that will focus on the 22 players to make the game more exciting for us. And in making it exciting, let's look at their personal growth. Let's look at issues that confront them, problems, and how do we fix these problems? How do we bring them to that decision-making table? What do we need to do? Can we look for one person who coordinates all activities that affect young people? Because when you go to health, you find something that affects young people there. When you go to education, when you go to interior, when you go to defense, almost every sector of this country, you will find issues and programs that we are doing that concentrates on young people. But then the issue is who coordinates it? And so we've ended up paying a lot of lip services to issues that affect young people, forgetting that they are in the majority. And so that is why President Mahama has decided that let me set up a ministry solely for them, and then let that person who sits there coordinate all the activities all the other ministries are doing, so that their issues are brought to the fore, and then we can help reset and fix the problems that affect them. And so to be able to do this, we must be very intentional.
What do you say to people who say that this is just going to be another duplication of role? Because you have just said that almost every ministry is dealing with something that affects the youth. And some argue that these are things that could have just still been done. Does it mean you're carrying all of the problems, the recruitment of everything in all of these ministries that you have mentioned solely to the Ministry of Youth Development and Empowerment?
So I like your question. They are doing something, but the question is, has it been done? If it has not been done, if there is no problem, if there is not a problem, you don't fix it. But because there is a problem, we all admit that issues that affect young people have not been given the needed attention in this country. What? Employment. Unemployment stands at 14.8%. It moved from 8.7% in 2016 to 14.8%. The danger that possesses to all of us, those of us who already have jobs. You'll say, well, if I don't have a job and I go hungry for 2 days, anybody who offers me anything criminal, I may likely do it. And so we must pay more attention to issues that affect young people. And so they are in the majority.
Okay, let's talk about employment, because it's one of the things that your party campaigned very heavily on.
Certainly.
To fix. What is your plan? There's a ministry for employment and labor relations. What will you be doing that is so different from what they will be doing?
So there is a group of people that falls between they are not in employment, not in education, and not in training. Very significant group if you look at the data. That group we must look at. Because if he's not in employment, if he's not in education, and he's not in training, the question you and I should ask is, what is he doing? What is that person doing?
So that's your focus?
No, that is not my focus. I'm going to get to it. Okay. So that is a group we must look at. To be able to employ people, one, we must make them employable. We must give them the requisite skills that would make them employable. Two, the world is fast changing. Technology is taking the better part of this world. And so, for instance, when you go to some parts of Europe, jobs that were available for human beings to do today is being done by robots. For instance, the job of bartenders and waiters in most of these big restaurants. And so, a lot of our young people are in the informal sector. How do we formalize what they are doing to get them ready for employment? So if robots are taking over people's jobs, then we need to be looking at how do we prepare our labor force to gain the right skills, the requisite skills, so that they are job ready or labor ready. Let's come to the issue of our garages, our mechanics in Abosioka and most of our big garages around this country. So a lot of them know how to fix cars the old ways. But today, a lot of the cars that are coming, I believe the car you drive is an electronic car, not an e-car, but then it's more of an electronic mode. Most of them are hybrid. A lot of them cannot even do the simple diagnosis. So if we don't prepare that group, in 5 years, in 10 years, they'll become unemployable.
So what exactly? I mean, for the layman who is listening to you, what is your plan to fix unemployment?
If you let me finish,
okay.
I'm driving home a point. So if we don't prepare that group towards the future, we'll have more crisis. And so the job, one of the main things we intend to do is to scale up skills, provide them with the requisite skills that they need to meet the job markets that awaits them in the future. Two, that group that I spoke about, not in employment, not in education, not in training, they are part of our society, and they are a significant number. So we must first identify why they are not in training, why they are not in education, and why they are not in employment. And then if it is jobs that we should find for them, we must create an enabling environment to create jobs for them. If it is because they lack training, then we must assess their needs and create programs that can train them. And if it's education they need, then we must provide avenues for education for them. And we've cut out programs for all this. We have the National Apprenticeship Program coming up. And what we intend to do with the National Apprenticeship Program is to assess their needs, create skills for them. And you see, we are not talking about just the normal programs we have done over the years, where a lot of things have been done, but we've not attained the results that we've been looking for. And so we are going to go back to what we've been able to do, what the various governments have done previously. When NDC was in power under President Mills and then President Mahama, we did the Less Debt program. What was the success story of Less Debt? Then people came to do NAPCO. What was the success story? What were the limitations? How do we fix it? And that's what we are going to do, to focus on it, fix it, and then get them ready for the job market. And then the third group, those who already have some skills, do we need to scale up their skills? So we are looking at the coders program. I talked about waiters not being able to wait in the next 4 or 5 years because of the job computers, robots are doing in other parts of this world. So how do we get them ready? We now know that the world is moving towards ICT. ICT is taking over. Technology is driving the world. Are we going to prepare them in that respect? That's why we are coming up with the 1 million coders program. We want to train 1 million young men and women in coding, the various skills of coding, so that they are also prepared for that job market. That is a big market. The BPOs and then the knowledge process outsourcing are venues where young people can take advantage of. With a computer and just data, you can sit in the comfort of anywhere in this world and work 24/7. We also propose a 24-hour economy. The law is going to be passed very soon. I know Guzitan and his team are working on. And then we are going to scale up. There are other things we want to do within the agri sector. There is a whole value chain within the agri sector that can employ people. But you know what young people look out for? Very attractive things. Over the years, we've not made agri very attractive. If we decide to look at agri through a different lens and then do the things we are proposing to do, looking for land banks, because our land tenure system has always been a problem in this country. If we create the land banks we intend to create the district mechanization centers we intend to create, you will find many more young people going into agriculture, because nobody wants to go and farm with cutlasses and hoes anymore. But if equipments are available, if land is made available by government and you don't have to go through the stress of acquiring land, I know many more young people want to venture into agriculture. And so we are going to create avenues and jobs for people. And we are not just going to create, we are going to make sure that we do a proper evaluation and a monitoring of the processes, so that we don't fall into the mess that we've ended up in previous years. And so we will do well. Just give us a chance.
Okay. I mean, I'm still struggling